Tell me when you're ready, Rebecca, and we'll start. Okay. Good afternoon. We'll open the hearing on Senate Bill 248 and welcome the prime sponsor.
I feel at home on this committee. I miss you guys. Thank you, Mr. Chair. For the record, my name is State Senator Tom Sherman, District 24, and I am introducing SB 248 relative to political contributions made by limited liability companies. I think just looking at the membership, at least 3 of you have been through this before, actually 4. This is the 3rd attempt that I know of trying to introduce this bill that would close what I consider a gap or a loophole that has been available for both parties, used by both parties, but it allows people to donate to campaigns through the LLC system without accountability. And that means that they can exceed the personal limits because there's no way to know exactly who's donating. And they can also, they could potentially not even be a citizen of the United States and be contributing to campaigns in the US. So with that, this bill, the first part adds language that would, in lines 3 through 6, make it necessary to report the donations of people, members of the LLC, and the second component, section 2, describes how that reporting should take place. So I think Olivia Zink is here to talk about some of the history of this and the impacts and how people have used this loophole to exceed their limits, and I'm happy to take any questions at this time.
Questions from committee members? Seeing none, thank you.
Thank you.
I need the sheet. And I hear Olivia Zink is on there, so we'll might as well call her up.
Good afternoon, members of the committee. For the record, hold on. My name is Olivia Zink, and I'm the Executive Director of Open Democracy Action, and I live in Franklin, New Hampshire. I wanted to wish you all a happy Valentine's Day and say that you can show love to New Hampshire by passing this important bill and closing the LLC loophole. We need to reduce big money in our politics, and this increases everyday citizens' voices. This bill provides transparency and accountability. As Senator Sherman explained, an LLC can make campaign contributions of the same limits as an individual, but if you have multiple LLCs, you can circumvent the campaign finance limits. I want to just sort of go back through a little bit of the history. In 2010, gubernatorial candidate John Stevens caused a stir when he raised $100,000 from 30 limited liabilities with 2 addresses in Massachusetts and Connecticut, all traced to Dunkin' Donuts franchised. At the time, this was called the Donut LLC loophole. In the same period of time, Kevin Smith had $99,000 from 50 LLCs, again Dunkin' Donuts franchise, and another $55,000 from 11 LLCs in Newington, New Hampshire, and Yonkers, New York, serving as the Planet Fitness health clubs. Nothing in our current law prohibits multiple limited liability corporation controlled by the same individuals. This law allows wealthy donors to exceed campaign finance limits. I also just want to know that, like in the 2010 cycle, 47 checks came from an 82 Flanders Road in Westboro, Massachusetts. So just so you know that there's a lot of money being funneled through one address. Governor Sununu vetoed this bill 2 years ago, citing that this bill would, I'll just quote him, "This bill would discourage the formation and maintaining of LLCs because it would force LLCs to choose behind maintaining confidentiality of their members and LLCs' right to make political speech." I just want to say that if an LLC wants to stay anonymous, then they can choose not to make a political contribution. They choose to make a political contribution so that that disclosure is known. I also brought testimony with me from Bob Perry, Susan Richmond, Linda Bundy, and Brian Beal. Brian's testimony also quotes a dark money report that I think is really important for folks to dive in to understand how people are using these loopholes. And Brian did some research in just a 6-month period of time. $147,000 were passed for LLCs in the 2020 election cycle. So 10 years ago, this was a problem. It's only grown worse in the 10 years of allowing this loophole to exist. And with that, I'm happy to take any questions.
Questions from committee members? I have one. What is the current campaign limits for a political advocacy organization?
They're unlimited. So if an LLC wants to form a PAC, they can form a PAC. They'll have to list their treasurer, which has to be a New Hampshire voter, in order to form a political advocacy. So out-of-state companies would have to find somebody in New Hampshire to serve as the treasurer of their political advocacy organization. And then that money is disclosed through the disclosure reports required for political advocacy organizations. And I think that if we want to, I think that it's best for us to not allow sort of Swiss cheese of campaign finance. If we want to force those LLCs to form a political organization, then that's what we should be doing, not having this loophole allowing them to circumvent campaign finance rules.
Other questions from the committee members? Seeing none, thank you. Is there anybody else that wants to speak? Seeing none, close the public hearing, and we'll be in recess for, I guess, 5 minutes.
Seeing it is 1:15, I will start the hearing on Senate Bill 348 and bring the prime sponsor, Senator Gray.
Thank you, Madam Chair, and thank you for letting me testify from here. My name is James Gray. I represent Senate District 6, which is Alton, Barnstead, Gilmanton, New Durham, Farmington, and Rochester. This bill, Senate Bill 348, has to do with political contributions. I was called over to the Attorney General's office for a meeting about political contributions, and they said that it was so complicated that they had to make a chart to try to help people figure out what it was. So that led to, well, if they have a chart that makes it easier for people to know what the laws are saying, why can't we put the chart into the law? And that's basically what you did, what I did, I should say. And right now, the chart has one thing in there that I was not in favor of last time, and that is that there still is a column in there for contributions after you declare yourself as a candidate through the primary, and then a column for before that. But they said that the statute that we had was not successful in doing away with that period of time and combining them, and that's why the 3 columns are listed. I'd hope to get this on your plate a little sooner so that we could have a spirited debate on it and come down and fix anything else that needed to be done. And there may be a little less time than what I would have hoped. So with that, I'll conclude my testimony.
Any questions from the committee? Seeing none, Thank you, Senator Gray. Olivia Zink?
For the record, my name is Olivia Zink, and I'm the Executive Director of Open Democracy Action, and I live in the city of Franklin. I want to bring up an issue with this bill. On line number 2, it says no contribution. This is the prohibited political contributions part of the statute. So adding the grid to the political prohibited contributions part of the statute feels out of place. It needs to go to the other part of 664 that's not prohibited political contributions, which is what this statute is. The second part, my understanding and my read, and again, I'm not a lawyer, but there's been litigation, so I would refer you to the Kennedy versus Gardner case in 1999, where this part of the law was litigated. Prohibited contributions say no contributions by partnerships or labor unions. We know labor unions can give, but they have to give as a segregated fund. And that lawsuit really said labor unions have to give out of a segregated funds. My understanding is limited liability partnerships also have to give their political contributions out of segregated funds. And so they're prohibited currently from giving to a candidate or a political party directly or indirectly, is my read of the statute. I know other people might interpret the statute differently, but I do think that the passage, prior to last year, the limits used to be $7,000. Last year, House Bill 263 changed that, but there was some confusion in that statute, which is why the Attorney General issued a memo on December 17th. And I think that's the memo Senator Gray was referring to. But I think that there's still some confusion, and this needs to be clarified on whether limited liability corporations are prohibited or if they're able to give $15,000 to a candidate. Because lines 2 and lines 18 contradict each other the way I read this legislation. And with that, I'm happy to take any questions.
Any questions from the committee? Seeing none. Thank you.
Thank you.
Is there anyone else here that would like to speak on Senate Bill 348 that has not been given the opportunity? With that, I'll close the hearing.
Since we have a little time, yep, we'll go into executive session if I have a motion. We have a motion,
Second.
have a second. Have a second, Senator Birdsell. All those in favor of going into executive session, say aye. Aye. Opposed? All right, we are in executive session. F&N bills, we have 4 of them. So,
Yeah.
SB 400 FN, I think that you talked to me about that.
I did, yes, and we should have an amendment, although I don't have a printed copy. I think I sent it to the committee last week.
I couldn't hear you, Senator.
Apologies, I don't have copies for the committee, but I did send it over last week, so, okay, you might, great. Thank you, Tricia.
Which one are we on? I'm sorry.
You
400?
might as well give me one. That way I can't say I don't have it.
Thanks, Tricia. Okay, so, this amendment, I hope, is fairly straightforward. The issue that came up in committee was a request by the judicial branch to make sure the timelines gave a little more deference to their already existing and busy process. So the changes that are reflected in Amendment 538 are to make sure that the deadlines created by the bill toll from the date that the record is received by the court, as opposed to the date of the land use decision. And then it sets up timelines drafted by the judicial branch for motion practice and for the ultimate decision. And so the end result is that it changes, the original language of the bill gave this whole process about 120 days to issue a decision. Now the court has approximately 160 days. So that is the change. Senator Bradley has seen this amendment. My understanding is he has no objections to it. The judicial branch has signed off on it. Housing advocates have signed off on it. So I think it should be non-controversial, but I'm open to discussion.
Other comments?
Can you explain how this coincides with the Housing Appeals Board? Because with the Housing Appeals Board, the planning board, like a contractor can take the planning board to the Housing Appeals Board.
Mm-hmm.
And I know in one of my towns, the planning board's been overturned a number of times. But if the town wants to go to court, they'll, I think, go to the Superior Court. What would be the process here? Is this once it gets to Superior Court?
Yes, exactly.
Okay.
So this is just the traditional court appeals process.
Okay. Thank you.
Yeah.
In my notes, had a asterisk saying RSA 14:9-A.
Yep.
Is that taken care of in this amendment, or?
Effective date. I have that note too. So I have that note in relation to the effective date.
That was Attorney Head's,
Yeah, he had
I
a,
believe that was Attorney Head's comment or concern that it give the court time to establish the docket. So I think he
Right.
wanted an effective date of January 1st, 2023, or was recommending that.
Thank you, because I do have that it's, that he wanted January 1st. Again, these changes were drafted by him and he did not raise that again, but I'm just looking at 14.9. It is provided, shall take effect 60 days after its passage. Okay, so I think he may have been calling to our attention that the original bill just needed an effective date inserted of January 1st.
If I could, I think
Yeah.
he was saying that the effective date of January 1st, 2023 should apply to just the judicial parts,
Yes.
that the other parts could move forward.
In the hearing report, says that he said, RSA 14:9A dictates that laws and constitutional practice and procedures shall take effect January 1st following passage, and they request that change. So,
Thank you. Yeah, okay. If the chair feels that's something we can do by committee amendment, I'm certainly open to it, but if you would like me to get that written into the formal amendment, I'm open to that as well. It's the wish of the committee.
I think on that one, we'll let you do a little bit more checking.
Okay.
And I know we're having problems with having too many mics on here, so I did forget to turn mine back on. But I think, we'll hold off on that and take a note.
Okay. Yeah. Thanks, guys.
So we're looking at with 400, just changing the effective date of that judicial section
to January 1st, 2023.
Correct.
Can we do a committee amendment for that, or?
We could, but I want to make sure that I get the right sections
Okay.
noted in for the effective date. And, I mean, we could try it on the fly, but, you know, the old expression, if you want it bad, you get it bad.
I'm more than happy to run a draft by the judicial branch.
And since we're almost ready for you to take over again here, then I accept the motion to come out of executive session.
So moved.
All those in favor?
Aye.
Ayes have it.
Thank you.
Thank you, Madam Chair. And thank you for letting me testify. And thank you for letting me testify from here. I am James Gray. I am a senator representing District 6, which is Alton, Barnstead, Gilmanton, New Durham, Farmington, and Rochester. I am here today on Senate Bill 365 relative to absentee ballot outer envelopes. And the outer envelopes was one of the things that we allowed moderators to do in pre-processing that assisted them in looking at the ballots to make sure that the people had completed the affidavits, which also allowed them to contact some people who had completed them incorrectly and make corrections to that. I believe that that is a useful thing to do. So the question comes up is, why do we need the outer envelope at all? And the outer envelope provides a place to put stamps, provides a place to put the address for the city or town, provides a few things like that. But for a person who votes in person or hand delivers that ballot, it really doesn't serve a useful purpose. Right now, the state of New Hampshire, there is a court order that prevents election officials from comparing signatures on the application and on the affidavit. I know back when I was a moderator, sometimes if a signature didn't look quite right, I would even go back to the original application and not look at necessarily the signatures, but actually the printing If I had a question about the signatures, looking for a reason to accept the ballot and not a reason to reject the ballot. The court order, in the judge's statements, it said that we needed a way to allow people to cure their ballot. So if they signed it and the signatures either weren't correct or something was irregular about them, that there needed to be a method that those people could at least attempt to cure the ballot to make it acceptable. The other thing the court said is that there would have to be training by the Secretary of State on the signature verifications. So, not hiding anything at all, this is one method that we can use by not having that outer envelope, and allow the clerks, when they get a ballot back in the mail, to be able to look at those signatures and contact the voters. Remember, all these voters will have filled out an application for that absentee ballot. On the absentee ballot right now, we do ask for email addresses and phone numbers and other things to help us resolve any issues out there with their ballot. And those are the things that I want to be able to have the clerks take advantage of, so that, along with, there is no reason that the outer envelope has to be there, as long as the ballot stays inside the affidavit envelope. And not having it in there allows me to pre-review these ballots, and if need be, contact the voter so that any irregularities can be discussed with the voter and hopefully cured before the time to process them. So those are the motivations for this. I know we have received at least one piece of testimony that says anything that you can do to make the process quicker and easier, they're in favor of. So with that, I'll conclude my testimony.
Any questions from the committee? Seeing none, thank you, Senator Gray. Olivia?
For the record, my name is Olivia Zink, Executive Director of Open Democracy Action, and I live in Franklin. I also am a city councilor there, so I serve in a role as a selectman on election day and oftentimes assist the moderator with absentee ballots as one of my duties on election day. I'm here today to speak in favor of this. I think this is a really important piece of legislation because it gives the clerks the opportunity to cure ballots. If somebody forgets to sign an affidavit or makes a mistake, there is an opportunity for that inner envelope to be viewed. It does not give the clerks permission to look at any ballots. The one thing that I do think, the application has the address, and so the address could be matched, but I think there are oftentimes maybe two people who live at, like a John Smith, a father and a son, a junior and a senior. And I think it's really important, I think that's where things get confused. And I think it's really important that there's ways for, to make sure the checklist is marked correctly, and that outer envelope is sometimes referred to sort for that middle initial or the junior or senior. The other thing is that some clerks print right from the online system with a barcode. So when that outer envelope comes back, they can scan it, because we have a system where you can look up your absentee ballot to see if it's been returned. And a lot of voters do check on their ballots. And so sometimes that barcode is helpful to the clerks. So if it's allowed for that barcode to go on the application or somewhere else, I think that's an important consideration. But I do think the other thing that was really important during pre-processing was that the time was posted when the envelopes were going to be opened so people could observe. So with that, I'll take any questions.
Any questions from the committee?
Would putting the voter ID number on the affidavit solve your problem?
I don't know if, there's not a lot of room on the affidavit envelope. It might have to go on the application because but there's also been other legislation that simplifies the affidavit envelope, so maybe there'll be room on the reconfigured inner envelope.
Anyone else with any questions? Seeing none, thank you. Tom Praisall.
Thank you, Madam Chair, members of the committee. For the record, my name is Tom Praisall from Demers and Praisall here today on behalf of the New Hampshire City and Town Clerks Association. I was just notified by one of the town clerks that, similar to what Olivia said, there may be a concern with the outer envelope not being provided the day of when the person comes in, and that's because it does have identifying features on it that they use to sort and get the ballots ready on election day, as well as for folks with the same name. Joan Dargy from the town of Milford has submitted written comments to you that just came in today, and I apologize for not having those with me today, but just wanted to share that with the committee ahead of any votes on this bill.
Any questions from the committee? Senator Susie.
So you'll be providing that testimony?
Yes, I believe
For
it may
specific concerns.
it may be in your inbox as we speak,
Okay, thank you.
and I'm happy to follow up with anyone on any questions or concerns.
Any other questions from the committee? Seeing none, thank you.
Thank you.
Is there anyone here that would like to testify on Senate Bill 365 that has not been given the opportunity? With that, I'll close the hearing on Senate Bill 365.
And
Motion to go into
we
executive
have a
session?
motion to go into executive session.
Second.
Second by Senator Susie. All those in favor say aye.
Aye.
Opposed? And we're in executive session. The next one down on the list is 405.
You need a motion?
If you want to make a motion.
I'll move on to pass for discussion purposes.
Well, we have a motion about to pass. Do we have a second? I'll second it. We have a motion about to pass, and I will second it. Okay, discussion.
I think some of the comments from Senator Gaida were pretty much apropos in that some of the penalties are not strict enough. And he's just basically going ahead and asking for additional penalties for any violations of election laws. Specifically for intimidation of election officers.
Now, in my notes, I said AG has some changes to this, and we'll work with Senator Gaida. I have not received an amendment that I know of.
I actually think I did mention it to him, and I haven't heard back from him. I can follow up with him. Do you remember what the amendment or what the concerns were?
Well, I was looking through, and I don't even see anyone from the AG's office who testified, so I'm guessing that the comment came from Senator Gaida himself.
I think the problematic language, at least as I see the bill, starts on page 1, line 30, where the Attorney General is supposed to notify a suspected violator. The language there is kind of curious. Because it's specifically saying without court action. It seems to take discretion away from the Attorney General in making a determination.
Mm-hmm.
And I think that might have been the issue that might have been raised.
All right. So we need Senator Gaida to explain, I guess. All right. All right, I'm going to ask that we rescind the motion right now, and I'll rescind my second.
Yep.
And we'll talk about 418. Last I knew from talking to Senator Gaida is that he had sent this over to Representative Lynn and that additional changes were coming. With my conversations with some of the people, especially the ACLU, I want to cut down the number of people that have to sign affidavits and by doing various things. Not that any of this is in a condition to put it into the bill yet, but certainly we had the bill that requests the last 4 digits of the Social Security number be retained in the DMV records and also be transmitted to the Secretary of State. I envision a system where if somebody doesn't have their license with them or whatever, that they can go over to the supervisor of the checklist, who would be the supervisor and possibly the clerk might be the only two at the polling place that would have access to that kind of information and conduct business there. The point is that, and using the testimony of one individual, said that there were only 66 people who the investigator couldn't identify. And my opinion is it's probably higher than 66, but given the 66, that's still too many. And how can I cut that number down and focus the investigator on the people that we're really interested in and not on people who, for one reason or another, either don't have the idea with them or whatever. When I spoke with the ACLU, I talked about providing a cell phone number, an email address, both of which the clerk or the supervisor could type into their phone, and at least get the demon mailer back and saying, this isn't a good address or whatever. If the person had the phone with them, so much the better. But, to make sure it was a valid phone number that they were giving. We already talked about that. But even as to requesting information like a person who would always know their whereabouts and address. And again, I do not want to make voting a burden on anyone, okay? But I do want to make sure that we thoughtfully and lawfully check on the various things that we have as requirements. So Senator Gaida is still working on the bill. The affidavit, if it's legal, I'm sure he's going to want to, to continue with that. We might be able to write some other information in there to cut down the number of people who have to fill out affidavits, so that if we are going to utilize Mr. Tracy's talents over there in the AG's office, that they be used for more productive reasons, so.
Do you know if he's actually working on it? Have you talked to him?
Tracy?
No, Senator Gaida.
Gaida, the last I talked to Senator Gaida, which was the middle to end of last week, that's when he informed me that he had sent it over to Representative Lynn
Okay,
for his legal expertise.
got it.
That there were some changes, part of which might be making sure that the lists were anonymous so that there wouldn't be an identification of the voter, in that, which I guess is a suggestion that either came from Representative Lynn or one of the other legal scholars that are trying to assist us in doing this, so. What is our due date for FNs?
March 7th.
March 7th? Ooh,
I just looked it up.
I still have 2 weeks to go.
Oh, wait, it says March 7th, 2019. I think it's supposed to be 2022.
March 17th, sorry,
Is it 17th?
it's the 17th.
What?
We don't have, is it March 17th, 2022?
Read
have
me
to-
what it says.
Deadline
Oh, the calendar? Oh,
master sheet.
It's
okay.
not what I have.
Well, the
All right.
7th is not, we're on Senate break.
Wait, this is from March
This is
20,
the calendar language right here. It's March 17th.
this is from
deadline for the committee to
2019.
act.
What did this
All right,
come
March
from?
7th.
Bill.
I'm sorry.
What?
17th, she says, committees to act on bills with a financial report.
Yep.
All right, so we
Kinda
do have,
late.
some time.
We don't have committee next week, this Monday's a holiday, and then we are on Senate break. So, we have to, next week.
You all need a break from me anyway, right?
They do say that March 17th is the deadline, but we are encouraged to do it sooner.
And we will try.
So, yeah, Monday the 7th is the next time we have committee.
Okay.
Okay,
That should be plenty of time to get these amendments done then.
yes, ma'am. So moving on from that, next FN is 427. And sorry to say this, Senator Susie, but I've got problems. I certainly believe in people requesting absentee ballots and sticking with the illness and not being in the location, which takes me to section, what is it, 9 or 10? Which is the pre-processing of absentee ballots. And I bring this up in light of the doing away with the outer envelope. Because the system, again, that I envision is that the clerk, when they receive one of these back, can now view the signature requirements. And so a lot of what was done in pre-processing actually could take place at this time. The ability to mark up the checklist, that this information, that a ballot is sent out to an individual, that the ballot is returned from the individual, are all fields that are in ElectionNet, and that by either highlighting or printing some kind of a code on the checklist, that I can accomplish the things that we allowed the people to do, highlight or make a small annotation, can already be done electronically on the checklist. So I guess, Senator, I'm not in favor of your bill right now, and your turn.
Well, there are a couple issues that I do want to address. One is that we still have the issue of people having to claim that they have a disability, when in fact they don't. They have a concern about potential exposure to their health. So the disability claim is still a problem, I think, for a lot of people. But the other issue with the pre-processing, I'm curious to hear what the town clerks have to say about the outer envelope, because I do think there is potentially some identifying information, and completely doing away with it in certain circumstances might actually make it a little more challenging to identify the individual voter. Look, the language of this bill comes directly from language that we had passed previously and that we actually saw in effect during the 2020 elections. And if anything, I think what it demonstrated is that these are improvements to the process that enabled more people to safely cast their ballot, that enabled the clerks and moderators to more quickly process absentee ballots and allow for the results to come out. So I think all of those changes that we made in anticipation of concerns with the pandemic worked out beautifully and successfully. We've had the dry run, so I would disagree with the concern, Senator, but I understand the process, so.
I'm certainly willing to look at the way the statute talks about disability, and trying to more concisely talk about people who, for health reasons, including disability, are unable or ill-advised to go to the polls. In taking care of that particular statement. We have in the past few years taken care of that mother who is at home with or without the car, who doesn't, finds it very, very difficult to complete her duties. We've taken care of her. We've taken care of all of the other ones that have come to us, but still kept the people who are, not in the community that day or can't get there because of voting, of work, to vote, and people who are ill or ill-advised. And that could certainly be the snowstorm, could be a lot of other things. When we look at the letter from the Attorney General and the Secretary of State, which was written prior to our legislation last year, certainly it made it clear that the existing law, even without the changes, would have allowed all of those people, due to the COVID pandemic, to vote via absentee. If you want to try and take this and work on those words for disability, I have no problem in giving you some time to do that. But I think we can come to an agreement on, the disability and, that kind of, we've been able to work together on things like that before, and I don't see that it would be a problem. So it's up to you, Senator, if that's what you want to do.
Yeah, I appreciate the opportunity to continue to work on the language to make sure that we address the concern. So if we could hold off till March 7th, that would be great.
Can I just make,
Yes, ma'am.
so in 654, on page 46, it says, it goes through the affidavit, fiscal disability, and number 2 is that I am unable by reason of physical disability personally to appear before the supervisor of the checklist of said town. Couldn't we do physical disability / health reasons or something similar to that?
And I think that's part of what Senator Susie will consider, because however the correct wording should be, I think, we all, whether it's, if there's an infectious disease and you're feared of going to a particular place, that certainly to me says you qualify under one of the two conditions, okay? Physically unable to appear at the polls, and the AG in his letter kind of tended towards that one when he was talking about people qualifying. But, I think that, working with us, we can get it done.
Certainly can work some more on it.
Okay. Any other comments on this one? So, we're not doing so well on finding ones. CACR is the first one on one of my lists. Oops. Okay. And I believe that one, we do have an amendment, is that right, Senator Birdsall?
Yes, it is.
Don't, oh, yeah, I do.
0602?
That is correct.
Okay.
0602S. So this amendment was reworded, or this was reworded actually from, I spoke with Representative Lynn, and it basically clarifies, it changes just a few words that on line 4, it's instead of every inhabitant, it's only a person who is a citizen of the United States and a citizen of the state of New Hampshire. So it changes every to only, so that it's, the fact is that if you're a resident of, you can only be a resident of New Hampshire and a U.S. citizen to be eligible to vote. It tightens up the language.
All right. Looks like everybody's reading, so I'll keep quiet for a minute. Okay, comments?
The other thing, just FYI, we have found that there are often states that have the language of every inhabitant of the state of, they have that language in their constitution. However, the courts have expanded the every to mean every person in that state is eligible to vote. They basically say, you haven't told us who can't. And this is, according to Representative Lynn, former Chief Justice, he said this clarifies that only and tightens it up.
Senator Burke Schofield.
Yeah. Thank you. So Senator Birdsell, I guess I'm still kind of trying to figure out what, even as amended, I guess what this does that isn't already in law, because, I mean, you're only allowed to vote, the Constitution limits the right to vote to people who are domiciled here, and our case law tells us that residency and domicile are essentially defined the same. They're defined by case law, they're not defined in statute, and this amendment doesn't define them either. So I guess I'm trying to figure out what is it adding to our process, because I guess, you know, the law already says that, you know, where you intend to stay, where you're domiciled is the same as residency, and that's where you're allowed to vote. So maybe you can elaborate on that a little bit.
Well, it basically, seeing some of the things that are happening in, let's say, New York State, who also has this language, the language we had in there before, that they have, now they've opened up the local elections to anyone, the courts have decided that they've opened up the city elections to anyone who's living there. This is hopefully tightening it up so that we don't have that issue. But it also, this is going to go to the people to choose what they want. To tighten up our Constitution.
Sure, I guess short follow-up, Chair, if I may. I understood that, you know, it will take another vote, but, you know, this is complicated, and I guess I feel that all it does is create another process by which, you know, we need to define residence and domicile, and that work's been done over the course of years. So for my part, I think it just creates confusion. And I don't currently support it as written, but I guess I am still just kind of struggling to understand where it adds to our existing law, which has taken years to kind of clarify itself.
I can appreciate that.
Okay, thanks.
Okay, so I think I've got a motion of ought to pass by Senator Birdsell, seconded by Senator Gray. You were a little slow, Ruth. I can change it. I can change it. Further discussion? Okay, so we're offering the amendment 0602S by Senator Birdsell, seconded by Senator Ward. Okay, further discussion? Seeing none, all those in favor say aye. Aye. All those opposed?
No,
Oh,
And we have a 3-2,
I'll take it out.
and motion.
That was on the amendment.
Yep.
Oh.
We have the ought to pass as amended now.
So
Second.
Well, actually, we did that one before, but that's okay. Further discussion? All those in favor say aye. Aye. Those opposed, say nay.
Nay.
And Senator Birdsall, you said you wanted to take that one out.
Yep. Oh, we did one.
Yes, ma'am. We're moving right along. Um, SB 241, I'm still of the opinion that that one ought to go away along with 54, is it? But I think there's people out there that are trying to politic me on that. Just a few, just a few.
Which one?
241, which is the Executive Council, and 254, which is also
Oh,
the Executive
yeah.
Council.
Sorry, I was looking for
And
251.
the fewer changes we make to that, the longer it can go without being a problem, so. The next one, relative to non-conforming structures and variances, by Senator Kavanaugh.
No, that was Mont.
Did
Huh?
you,
Never mind.
there's 243 too.
Yeah.
240,
Yeah.
okay, you want to do 243?
I-
We'll do that one instead.
Just pointing out that.
Okay. This one here, the notes that I have would need to be amended. Do I have an amendment on this?
There is an amendment in there, 0220S. Never mind. I
I
have
don't have
244.
Okay, so 243, I don't think anyone adopted this orphan. And from was it Representative Griffin who testified on that one, that they needed to be able to, oh, no, it was Cragen. They need the ability to refuse it.
Yeah, yeah. And that's a, I think, valid concern.
So is there anyone that wants to adopt this orphan?
I'll adopt the orphan. I don't have enough kids, I need another one. And too easy. But just to get the committee's input, I think the intent here is good. I think it's just that ability to refuse that raises a concern for me. So that's like lines 10 through 12 on page 2. And that would probably be where I would focus my efforts unless there's anything else.
Who was it? Was there anybody against it? Anyone? No.
The only other question that I had was, how are the rights of any debtor
The
taken care of?
creditor, yep.
So, yeah, creditor is much better. Daddy. Certainly, you all know that I would like to change the way the system works right now anyway, but if we're going to do this, then we still need the ability of someone who has a legal claim against the estate to be able to exercise that claim. So if you would, when you look at that, also look at that portion of it.
I will attempt to.
I'd certainly like to make it easier for people.
Right. Okay.
If you want to do that. Mr. Head said he would clarify on it.
Oh.
Which sections?
Wonderful. Thanks, Tricia.
Because the bill would impact the court proceedings, RSA 14:9 dash small a, which governs the effective dates of legislation, says that the effective date should be January. If that change can still be made, appreciate it. But see, he doesn't tell me in here whether it's the legal section or the whole bill. And was it you, Senator Perkins Coker, were doing that? So I'm gonna pass that to you.
Okay.
Because that's still the issue. I don't have any problem with making the effective date
There are other parts of the bill that
January,
should
but
go into effect sooner.
if we're going to do,
Yeah, I agree that that's still unclear. Okay.
Senate Bill 244.
So we're not doing 243.
We're going to, Senator Perkins Coker has graciously accepted that orphan bill and is going to,
This is where the amendment was.
yeah. Okay.
I don't have a hearing report.
244.
There is one.
Sure, if you have one.
I don't think one got in my packet either.
Yeah, me neither.
Well, let's wait for a minute because I have problems with the bill.
I would love the amendment. Thank you.
The first problem I have with the bill is it crosses out the hardship part. Owing to special conditions of property that distinguish it from other properties in the area, which is the hardship statute in that land use thing. And taking that out of lines 9 and 10 seemed to me to be problematic. That you want to have a criteria that says, yeah, we're going to let you do something like that because, and so that was problematic for me. And then certainly the environmental people are not happy with a breakup of a particular portion of land that could cause the water quality standards to be violated, okay? That certainly they are interested in making sure if there's wells on there and a septic system, that the required radiuses are met and can be met in the future if you're going to subdivide this property. That whether it was this committee or one of the other committees that I'm on, we've had major discussions over that kind of situation in the past, So if it were me, I'd put this one into interim study. And leave it there for the rest of this session. I understand, and full disclosure, the people who were here are in my Senate district. But I also have concerns that the property is right there on the lake. And just because there hasn't been a demonstrated problem with the way that the septic system is working, doesn't mean that there's not a problem with the septic system. Things that have happened in other communities, septic system had a overflow pipe that took everything away, and even though there was a problem, you would never see it. So that is what the environmental people are saying, is that there needs to be some kind of provision, and I'm going to use my words and not theirs, is that a septic system and well plan can be developed if they're not on city water, city sewage, town water, town sewage, that would meet the environmental criteria. Because if you do divide this up and you can't meet the criteria, then where are you? And if the state is the one that's already saying you can subdivide it, then where is the state's liability and responsibility? And I don't know that the amendment that was put forth by Senator Kavanaugh does that for me. Comments?
Isn't the change in section 2 owing to special conditions, isn't that to try to, special conditions is a vague term. It's not a term that is defined, I mean, it's been defined in some cases, but it's unique to each situation. I think this is trying to create a little bit more uniformity.
I guess I have gone back and forth a little bit on section 2 because in my mind, I mean, this is a substantial change. There is a lot of case law around the existing variance language, so I think it's important. But I mean, owing to the special conditions of the property, my understanding is that that's often used to help identify, unique characteristics of a parcel so that the board can consider how those interact with the zoning ordinance in a unique way. And so I think they serve a purpose. Without them, I've gotten feedback that this might make variances harder, it might make variances easier, but it is a big change. And so I guess, I could support it, but I guess I'd do so hesitantly. But I also think studying it a little bit more might be helpful. So it's not a clear answer from me, but.
Well, in my mind, combining the question about the special condition and then the concerns of the environmental people was the reason why, instead of an ITL motion, that I said interim study, but the likelihood of myself doing any of that study was probably very low.
I also think section 1 might be addressed. I mean, my understanding is that existing laws, as long as nonconformance doesn't increase by more than 25%, you know, they don't usually trigger. Like an existing nonconforming structure that was renovated to be converted into an ADU wouldn't necessarily trigger the zoning ordinance as long as the nonconformities didn't increase by more than 25% already. So maybe it's intended to be a clarification, but that's always been my understanding of the law.
But
And you're
we're
trying to
putting that
arrive at a
in-
recommendation,
We're
so.
we're putting that in the section that talks about subdivisions, though. So
Yeah.
it's telling me that I'm transferring ownership of at least portions of that property. And that if I don't have a good understanding of where the well, septic system, and have easements that cover all of that so that the maintenance can be done, should maintenance be needed, or should say when maintenance is needed, because the septic system, it's not if, it's when. That certainly, if I can't get a system in there that meets the current statute, why would I do it?
I guess to provide additional housing if you're not increasing the septic burden. But it's complicated.
The last time that we had one of these, when we finally got the final statute, we talked about a particular date, I think it was like 1985, and that if the plan hadn't been filed with DES, prior to 1985, then they needed to file a new one. We really got down in the weeds in this thing, and I can't quite get there, So I guess I will formally make the motion to interim study.
I'll second.
We have a motion and a second. Further discussion?
I just find it's odd there are three separate things in this bill.
All right. All those in favor of interim study, say aye.
Aye.
Opposed?
Opposed.
Couldn't tell if that was a 3-2 or a 4-1.
4-1.
4-1. Okay. Who would like to take that out? I guess I will.
Senator Susan.
So I will take that out. I can keep my big mouth shut, right?
We have a lot to say about this issue, so really. You should be the one to bring it up.
Okay.
How about Senator Kavanaugh's
No, it's okay, Lori.
other bill?
Which one is his?
Yes, I do
250?
understand that, thanks.
No.
250 is Parsons.
Well, why don't we just,
Yeah,
since we
325.
since we have some time, let's just keep going in numerical
Okay.
order for right now, and because we're going to skip a couple. Establishing committee to study agreements between developers and municipal trash removal. This is the study committee that we talked about, but there was some discussion about putting that and private roads together.
My recollection was that you suggested that. I don't know that the rest of us discussed it, Senator Gray.
Well, that would constitute something.
Yeah, I just,
At least I didn't lie, right?
You didn't, I know there was mention of possibly putting these together, but I do think they are discrete issues. The trash pickup and the road situation, and I just think keeping 245 the way it is and actually doing that study does make sense.
So let me pull 245 out of the folder. Sen-
I think 245 in and of itself, the trash removal piece is a distinct enough topic that it should be studied and it warrants study. And then your bill and Senator Carson's bill are also a distinct issue dealing with roadways within these communities.
Okay. So 245, one member of the Senate. And Senator Sherman is the first senator listed, so.
His bill? I would move.
He would be the prime candidate, wouldn't he?
He would be.
Yes. Anyone have any problems with the duties? So I think I hear a motion of ought to pass from Senator Susie. Senator Birdsell, seconds.
Ought to pass.
Further discussion? Seeing none, all those signify by saying aye.
Aye.
All those opposed? Consent?
Second?
All those in favor say aye.
Aye.
Opposed? Senator Susie, you get this one.
Okay.
So 246 and 250 are the two that we've just talked about. Yep. And Senator Carson's, right? Yours and Senator Carson's.
Some of the feedback that we added,
Is this amendment 0600?
So-
what this amendment does, I think on 27 on the amendment, it says, no city or town shall approve plans for. No city or town shall approve plans for a qualified private community unless the declarant agrees to at least one of the following. So it adds the choices to either establish a capital reserve fund so that the condo or the homeowners association has some seed money, but it also gives them a chance to build the roadways to the design standards of the municipality.
Okay, amendment to 246. These are different. Okay, so 246.
Comments?
So, sorry, Senator Brickell, just to clarify, the two changes are,
I'm sorry?
the two changes from the amendment.
On line 29 through 31 on page
Yeah.
1,
Yep.
and on page 2, line 1 and 2, it basically gives the private community, it gives the town, it allows the builder to either put in a capital reserve fund for future improvements to the road or
Yeah.
maintenance, or it lets them build the roads to the municipality standards.
I see. And just a question on that, did you get to have, here, let me take this off. Were you able to have any conversation about, whether a municipality, if there was an example of a municipality that would be willing to take over care of a road if it was built to that public way standard?
I have had a conversation, I think in the very beginning, when Senator Carson and I were looking at putting in this legislation, we had a meeting with the private roads. There were one or two towns that they refused to take over the road because the private roads wanted them to take it over, and they refused because they weren't built to the standards of the municipality. And in order for them to take it over, they would have to have them built. The other, I don't know if this relates, but in my case, for our condo, we're in a condo association, and we had asked the town at some point, would you be willing to take over the maintenance of our road? And they refused because they wanted to put a pass-through for, through our woods from the fire station so they can use it to run through, so we chose not to. But, yeah, it has happened on a couple of occasions.
Okay, thank you.
I think it might be in the hearing report too, but I'm not sure.
The 50% of the road, when it's completed, I guess is the way it's worded, or close to that. I have lived in my current house 45 and a half years now. And in that time, the city of Rochester has paved it once. And it wasn't fresh pavement when I moved in, so.
You need a better city council.
Maybe I do, maybe I do, you know? But the cost of pavement, okay, and what we're expecting it to do, I mean, I just don't want to give people the false impression that this 50% fee that they pay, you know, towards this is going to take care of half of their road in 20 years, which it won't, but.
Well, in what it does say in line 29, the declarant will establish a capital reserve fund of no less than 50% of the cost to replace all roads within the qualified private community based on the cost estimate as described in paragraph 2. In paragraph 2 on page 3, it says the declarant shall submit a written estimate of the cost to replace the roadways in the qualified private community for approval by the city or town. The estimate shall be based on the projected cost to replace the roads on the projected completion date of project.
So do I have a motion on Senate Bill 246?
I move on to pass.
Second.
And I'm also thinking that both of you are going to offer amendments 0600.
So moved.
I'll second.
Okay. Any further discussion on the amendment?
No, I'll just offer the comment that while I agree this is, it is a proactive way to address this, I guess, I just remain concerned that this 50% fund is a cost that the developer is just gonna directly pass on to the initial condo owners who take over the development, and so as a long-time affordable housing advocate, you know, I have a concern about adding that to the price of the home. You know, I guess I'm still trying to get convinced that this isn't really just a duty of the condo association, you know, to take that cost estimate and create appropriate condo fees and reserves over the life of the condominium. So I appreciate this effort, but I just won't be supporting today.
Okay.
Further discussion? All those in favor say aye.
Aye.
All those opposed, nay? Nay? So we have a 3-2. That's on the amendment. And ought to pass as amended. Further discussion? All those in favor say aye.
Aye.
All those opposed say nay. Nay. And Senator Birdsall, I think it's yours. Since I've got Senate Bill 250 pulled out, we'll skip 247 for a minute. And this was tax credit for private communities.
250.
Yep.
Did Senator Carson have is this her amendment for this one?
0676 is the one I have. My comments on this, to try to remain consistent, tax structure in New Hampshire is based on value of property for your property tax, not on the services that you get or the services you don't get. That for things such as water, sewer, we form a separate entity, and those are based on what you get for services. If you use it, you're charged. If you don't use it, you're not charged. For roads, schools, trash, if I were to try to get to this, and I were doing trash, I might try to form a trash district, okay, and have it a service-based fee, based on getting the trash removed or not. I find it difficult to offer that same kind of a thing when I'm trying to do roads, because somebody has to pay for the road outside of City Hall. So to me, it changes the very basic premise that we use here in New Hampshire is based on the value of your property, you pay taxes. That some people think that's right, some people think it's wrong. What is going to stop the people who don't use the school district to come in and say, don't use the schools don't want to pay for them. People who don't, any of the services that the city provides. So for those reasons, I find it impossible for me to warm up to this. I'm sure that you ladies will offer some enlightenment to me and make me understand why that's not a good opinion, but I'll shut up now and let you all talk.
Well, I disagree with you that I don't believe that the homeowners associations, and I may be alone in this, I get that, but I don't believe that the homeowners association or condos get, their taxes have gone down because they pay for their own services. I believe that they're comparable to the taxes that single homes single homeowners have who have their services included in there. So because of that, I will be supporting this.
Senator Perkins.
Yeah, thank you, Chairman Gray. Well, generally speaking, I do like the tool of enabling our municipalities, to use tax credits. I guess I think along similar lines that you do, Chairman. Every time we create a tax abatement for someone, that tax is further distributed onto others. And so, as a city councilor, this would come up, but, I think making sure that we have our next generation here to take over our economy means that, we all need to be sharing in our tax burden equally. And so I think keeping our taxes distributed the way that they have been is the most equitable, and it's also the smart way to make sure that we're all investing in our public infrastructures together. I live in a home where, I have to hire a plow to come plow my driveway in addition to the roads that are in front of my house. So I do appreciate this hardship, and I do hope we can continue to work on this issue, but I'll be voting against this.
Further comments? Do you want to make a motion at this time, Senator Britzel? Or
I'll move on to pass.
we have a motion of ought to pass. Do we have a second?
I'll give a second.
Okay. And I'm assuming that you're moving amendment 0676 also, Senator Britzel?
Yes.
And Senator Ward, are you seconding that?
Sure.
Okay, further discussion? All those in favor of amendment 0676 say aye.
Aye.
And all those opposed say no? No?
No.
That looks like a 2-3. Motion fails. Shall we hold on this one?
No. I know it's going.
I'll make a motion of interim study. Do I have a second?
Second. What was your motion, sir?
Interim study?
I'll second that.
Okay, I've got 2 seconds now. Further discussion? All those in favor say aye. Aye. All those opposed say nay.
Nay.
4-1. And who wants to take it out?
I'll be happy to take it up. Interim
And we skipped over 247. We've been awful quiet in the back, you know. Maybe if I'd taken this one up before 250, I would have lost an audience member or two.
Was I supposed to be working on 251, just out of curiosity?
I'd
That's
have,
the advisory tax increment financing.
I'd have to get to my notes and
There was
I haven't-
opposition to it.
Yeah, I think NHMA was concerned.
I can't find my bill, my folder, so. Oh, okay.
all
I
right.
was concerned about the membership, I think.
Yeah.
Right, and we were looking at making sure that the business owners were a minority in it. So I wasn't,
Or just that some members of the board were members of the affected district, yeah.
yeah.
Well, then, let's look at 251 if you guys are
I
already,
don't think it's ready.
Huh?
I think it needed an amendment. I don't
Yeah, it needs an amendment, and that's why I was just asking if I was supposed to be working on it, because I can't find my folder.
okay, so
I'll work on it.
251, we'll mark that down as Senator
Not
Birdsell's working. All right, 247. My objection to this is that there was a hard-fought agreement, must be 5 years ago, Senator Sisley? Where we really did hash out these issues and wanted not to put the community in the place of competing with someone who had a contract in the community for having broadbands. And this bill does away with that. And I have a problem with that. And I will take comments from whomever.
I would tend to agree, Mr. Chairman. In addition, I think many of the issues raised by the proponents had more to do with questions of quality of service as opposed to not having service. And I think we've recognized as a statewide policy that extending service to those who don't have it at all should always be the first priority. And then there were also a lot of comments made about the fact that communities taking, if this were to pass, communities taking this on could very, very quickly find themselves with large expenditures and very rapidly outdated technology because of the way technology changes over time. So I share your concerns and those as well. So for those reasons, I'll vote against it.
Is there anyone that wants to speak in support of it? Okay,
Can we interim study it?
yes. I have a motion from Senator Birdsell, interim study.
Second.
Any further discussion? All those in favor say aye. Aye. All those opposed, nay. And do I have a motion for consent?
So moved.
Second.
All those in favor say aye.
Aye.
Opposed say nay. And, I guess then, Susie, I'll ask you to take that one. Sure. Yes, ma'am.
Excuse me for a minute.
Okay, and said that it's sections 8, 10, and 11 of the bill that would be the January 1st effective date. And so I think we'd be able to draft a committee amendment based on that information, unless you would still like me to have it written up.
I think I do want to have you have it written up. We're doing pretty good on other ones right now, so.
We have time.
And it's not even 3 o'clock yet, so. 251, TIF districts, that's the one you said needs an amendment.
Yep.
252 is information on property tax bills, Senator Susie. And seeing as she's not here, we'll '54 is executive council, we've already talked about that. 255, Senator Perkins Quokka's bill.
So, this was my bill to establish redistricting criteria. There was a request to amend this so that, the criteria would apply to executive council districts as well as, to include educational criteria in creating communities of interest. I am more than happy to bring back an amendment to do that if the committee would like me to. But I thought I might get the temperature of the committee before I did that.
Would you speak a little louder? I have trouble hearing you.
Yes, ma'am. I said, there was a request to have an amendment to this bill, which I am happy to do, but I thought I might get some comments from the committee before I drafted a formal amendment.
Where are we on?
We skipped yours for a second
Okay.
to go to Senator Perkins Quokka bill.
Okay.
255. Certainly, we've had lots of discussion. This bill has been in front of this committee in other forms a couple of times probably now. Certainly any maps that I was involved in drafting, there was multiple criteria that were used. Paramount among those, but not over, was the one man, one vote required not only by federal law, but I believe it's Part 2, Article 9 of the New Hampshire Constitution. So at this time, to try to save you, a little bit of effort, I would offer a motion of interim study on this.
Second.
So interim study moved by Gray, seconded by Senator Birdsall. Is there anyone else who would like to speak on the bill?
I'll just make a quick comment, which is that I appreciate it being studied. I do think I'd love to see a day where New Hampshire had requirements like this in statute. I think it would make the redistricting process clearer, not only for us as legislators, but for the public to follow. I think these criteria are what the public wants and wants to see as legally binding criteria on us at any time that we're acting to redistrict. And so they provide remedy to make sure our districts result in fair districts. And I hope to work towards that with members of this committee.
Yes, ma'am. Any further comments? All those in favor of interim study, say aye.
Aye.
All those opposed, say nay.
No.
Nay.
And I will take that out. On 252.
Well, since this is my bill, I should probably lead off by just saying, I think this is simply an issue of transparency and disclosure. No one appeared in opposition that I'm aware of, because I don't have the hearing report on this one, but you know, with regard to education funding, it's certainly something that we have worked on for decades, and I think we'll continue to work on. And I think more information for the general public about how tax dollars are being used is a very important thing.
My comments on this were kind of involved in one of the questions that I asked at the time, that, and per the testimony from the union representative, the Concord School District, it was estimated that they received about $5,000 from the state for services, and that the cost of educating a child was $10,000 or more. I think that they was like $3,600 that a normal child would get, you know, in normal state aid, and if there were other conditions, that would increase. Oftentimes when people talk about whether or not there would be savings if one child, two children, three children, certainly, you know, that if a class is 25 students and you take one away, that doesn't seem to do anything. But I offered as an example the East Rochester School in Rochester, which because of teacher contracts and various things that they had already hired the teacher, and that the enrollment in the kindergarten that year came out such that the classes, I don't know whether they were 12, 13, 13, or 13, you know, 12, 12, or whatever, but clearly there are cases when distributing those students, if I, you know, were to get down 12, 12, and 12, I'd still be within the state law, having 18 children in 2 classes instead of 12 children in 3 classes. And also from my experience in Rochester, that when you get to the middle school and you get into the high school, that these savings are actually easier to recognize, because now I'm taking those children from multiple elementary schools in a city like Rochester, and so combining them together oftentimes leaves me with 1 or 2 less teachers, or even more than would be required were those students out in their, and I'm going to call them districts because Rochester is broken up into districts where the children in the elementary schools are tried to group together by their location. And then again, even further groupings when you get into high school. So, you know, there is certainly the possibility that there actually could be a savings. You know, but the property tax bill is to tell you how much of your money is being spent for the city, the school district, the county, and then how much is going out in state aid, but in most communities, that's refunded right back to the community. So for those reasons, I can't support the bill as it's written. Further comments?
I would just say that, as you mentioned, there are separate lines on the tax bill because money is going towards county expenses, money is going towards municipal expenses, money is going towards school expenses, but this is outside of the school district. So that's why it makes sense, I think, to add that additional line because, once again, you're showing where those dollars are going, just like they are going to separate political subdivisions, such as the county.
So would I be taking current day, or shall we say 2 years ago, to make it easier, if you have a Catholic school in your community, what expenses is the city or the taxpayer in that city paying, and what would be shown on the tax bill in that situation? Because the state, none of the state funds are provided currently that would show a zero. And that the difference now would be that there would be that 3,600 shown. But that would be state funds and not city funds, correct?
Correct, it would be state funds. It would be
And
going into the freedom account.
the state funds would be coming from where?
The general fund, at the rate things are going.
And that general fund is replenished by property taxes? Is that why it's here?
The general fund is made up, as you know, of a number of taxes, but we're talking about the taxes that are going to the local level. So just like the statewide property taxes you said would go back, it is a payment at the local level of property taxes that's being diverted.
Okay, so,
We can agree to disagree.
but how much of the property tax that bill requests are actually going into that fund? The education fund?
It's the statewide property tax accounting that would be diverted.
Whether or not, I have been led to believe that the statewide property tax never makes it into that fund, that it is pretty much rebated to the local community. Am I incorrect?
It depends on the community. Some communities it is diverted, some communities it, but the point is that it's education dollars that are provided by the state that would otherwise be going to the community to support education within the public school that's now not going into the public school system.
Comment.
Thunder?
On the property tax bill, there are three things. And I think we have discussed this more than once because people keep thinking about this all the time when they're being told it incorrectly. There is no property tax money that goes into the fund that supports the EFAs, none. The EFAs are supported by other funds. And that whole thing is being perpetuated because people have called me up and said, you're going to increase my property taxes with this EFAs, and that is not true. The property taxes stays in the local community to support the local school and the county, and I think the third thing, I can't think of what that is. And I think that to continue to say, even to write it on your property tax bill, that your property taxes are going to go up because of this is totally incorrect. If you want to provide information for the people in the community, I think you need to write something much longer than this explaining where the taxes go, how much money is going to the EFAs, how much is being distributed, and at the end is going to be that none of this is going to affect your property taxes. If anything, the property taxes over the years, I think, is going to go down, because if you have children leaving and doing something different, yes, the aid goes down. But if you looked at the costs that different communities have of educating their children, they run anywhere from $15,000 to $20,000. If you have fewer kids, you're not going to spend that kind of money on the school, on the staff, on whatever else. And I think it's to put it to put extra stuff on a property tax bill to further have people thinking that the property taxes are going up because of it. I just think it's not truthful. If anything, you should put a line there in red saying your property taxes are not affected by this. It's not going to support the EFAs.
Additional?
Do you want a motion? I move ITL.
We have a motion of ITL.
Second.
Further comments? All those in favor say aye.
Aye.
All those opposed say nay.
Nay.
3-2.
I'll be happy to take it out.
Senator Ward? We'll take it out. $325.
There is an amendment, I believe.
I'll move on to pass.
Second.
Now, I had a note on this one for 1 week, and I guess that is the reason for the amendment, right?
Correct.
Right, I think there, Senator Kavanaugh wanted to ensure that it was placed into the right RS.
I don't think I have a copy of the amendment in my packet. I know it's my fault, but hey.
Yeah, I need one.
I have it. I don't have the bill, but I have the amendment. I don't know what's going
The
on
bill
here.
is like one pager.
Well, the bill replaces section 1, and section 2 is the effective date, so.
Correct.
So my biggest concern about this was that they would be including the Public Works personnel into the RSAs that I was working with the firefighters and the police officers and dispatchers for the PTSD, but in fact, it's actually going into the emergency management, Homeland Security and Emergency Management, RSA, and for major things like hurricanes and floods and pandemics. So he clarified, it's clarified because I think it's in definitions in Homeland Management, Homeland Security and Emergency Management, so.
So I think I hear a motion of ought to pass.
Yeah, I already did that. Senator Susie seconded it.
Senator Susie seconded. And are the same for the amendment?
Sure.
0684, Senator Birdsall and Senator Susie. Further discussion? All those in favor of Amendment 0684, say aye.
Aye.
All opposed, say nay. And ought to pass as amended. Further discussion? All those in
Consent?
favor, say aye.
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 Do we want it on consent?
It's good for me. I have a motion for consent.
Second.
All those in favor say aye.
Aye.
And who would like to take that out?
I'll take it out.
Senator Birdsall.
Well, we're not doing FNs, but at least we're getting a lot of those out.
All right. And the last one that I have for us to look at today is 334.
And 334, Chair, I've adopted that one too, and
Oh, yeah.
we need a little more time.
Okay.
Wow, you are busy.
I'm just trying to be helpful, you know. That's why we're here, to be helpful. I will try to have an amendment for you when we meet again.
All right. I think with the great things that you did today, that since next Monday is a holiday, we will take it off. If, depending on what they do with session, if there's a reason to get back together, I think that we're pretty much in control, so I don't know that we would have to. But if somebody just can't resist, sharing their time with the rest of us.
You think we're in control?
We've heard all of our Senate bills, correct?
Yep.
So
Yeah.
at this point, it's just execing, and then if House bills come in, but
We do have 2 or 3 more House bills that we can start to act on. They were out of the first batch that came out of the House from their retained bills. So our next committee day, you can start scheduling those.
So that would be March 7th.
Okay?
We will exec the FNs and hear those 3.
Yep. And that should keep us right up on track. Anyone else for anything for executive session?
You're not doing 325 then?
We did 325, I think.
It's on consent.
You voted for it.
That was the last one we just did.
Okay.
That's the emergency management. Adding,
Did you want to?
334.
interim study.
334, Senator Perkins Quokka told us that she needs a little more time
Okay,
on that.
fine. I had the wrong number.
Yep.
I saw this, you said something, but I couldn't hear what it was.
I will try to speak more clearly, Senator.
Speak out, enunciate.
You are not the first person to say that.
You
just soft-spoken.
Well,
I used to be that way, until I went into the Coast Guard.
Seeing no other discussion, I entertain a motion to come out of executive session.
So moved.
We'll have a motion and many seconds. All of us in favor say aye.
Aye.
We're out of executive session, our business being completed. We are adjourned.
Okay, I gotta put all of these things back in.
I'm leaving the ones we just execed out. I just have the patience to put them back in.
I'm just gonna split them up here. Put them in any which way.
Marie's gonna take them out anyway. Ow.
Marie doesn't like it, she can arrange it.
Given your communities, that's no surprise.
Olivia, we'll look at that envelope and make sure,
Yeah,
because
So I had all the four holders trying to. The address is on the application.
right, the address is on the
Really need new
application, but I think the
I just got
application
these.
also has the voter ID number.
Contacts and I still don't know where.
That's,
Okay.
but I will check,
On the outside envelope, I don't know.
I will check to make sure that there is sufficient
My like regular passes.
information to, it's, you know, to tell who it is. But we need the name so they can get in alphabetical order.
you see, I put my computer glasses on
And then
at
if
home.
the
My
voter number
my
is there,
stepdaughter
and that's
texted
on
me
the,
the other
already on
day.
the
She said,
checklist, then those two things
I'm-
become a unique identifier.
I have wrinkles
Actually,
around
the
my.
voter ID is a unique identifier.
I'm getting old, I said.
The name
happens to the
becomes your
best of us.
cross-reference on the checklist kind of thing.
And will you pick up House Bill 52 the next time you, or?
52,
It is 50.
there are people who are politicking me right now on 52 also. And I can tell you that as soon as I believe that